Massive Human Rights and Freedom Initiative welcomes you back again. We use this period of public holidays to discuss once again on the issues of justice system, court orders, and the reluctancy of governments to obey court orders and the rules in Africa. Our case study will be on Nigeria and its system of obedience to court orders, especially at government sector. The center point will be the government of Mr. Muhammadu Buhari, the president of Nigeria, and the Nigerian leadership disobedience to court rules and orders. This discussion is based on the publications of various newspapers in 2019, especially in November 25th, 2019, whereby it was reported once Buhari has disobeyed 40 times Amnesty International lawyer. Another one, the litigate says Buhari has disobeyed court 40 times Amnesty International lawyer. I quote, a legal advisor to Amnesty International, Dr. Kolawole Olaniyi, has said that since assuming office in 2015, President Buhari has shown stunning disregard for the rule of law and human rights, ignoring Nigerian judges on at least 40 sections. The London-based lawyer who accused President of Nigeria of treating judges with disdain also questioned the sincerity of Buhari's anti-corruption fight. Unquote. You will watch the interview of the international lawyer.
Dr. Kolawole Olaniyi, who is legal advisor to Amnesty International, has said that President Muhammadu Buhari has shown stunning disregard for the rule of law and human rights, ignoring Nigerian judges on at least 40 occasions. The London-based lawyer who accused the president of treating judges with disdain also questioned the sincerity of Buhari's anti-corruption fight. He said, and I quote, "It's hard to overstate the significance of this disregard of court orders, not just for the operation of the rule of law, but also effective respect for constitutional and international human rights, such as freedom of expression, peaceful assembly, association, and access to information. Yet, Buhari is carrying on irrespective of human rights and the rule of law. Anytime the courts have told Buhari's government to do something it doesn't like, it has refused to obey it." Even Buhari's Attorney General, Abubakar Malami, once said, "The rule of law is what the authorities determine it to be. Yet, it should never be right for the government to obey the court as a matter of grace. Buhari has to obey the court as a matter of necessity. If Nigeria is ever going to comply with its international human rights obligations and commitments, the government has to begin to show respect for Nigerian judges." End of quotes. All right, here we are, Chris Chilaka.
You know, each time we put the Nigerian judiciary against the executive, what we have given out in Nigeria is many years of
That accused President of Nigeria of disregarding the judges' orders, disregarding the rule of law and the human rights. The Amnesty International lawyer made the world to know that the public perception seems to be that the government will only obey court orders if it gets what it wants. Yet, it should never never be right for government to obey the court as a matter of grace. Mr. Buhari has to obey the courts as a matter of necessity. If Nigeria is ever going to comply with its international human rights obligations and commitments, the government has to begin to show respect for Nigerian judges, unquote. This brings us to the point of discharged and acquitted, or acquitted and discharged, the proper court order upon a finding of innocence, a consideration that government has to accept. The review comes as a result of the case between Federal Government of Nigeria and Nnamdi, Kanu of indigenous people of Biafra. The word acquitted, when used in legal sense, implies a legal decision given by a court of competence jurisdiction to the effect that an accused person is not guilty of the offense which he has been charged with. Its import is that the accused has been officially dismissed from a charge or the charges. Discharge is an order of a court of competent jurisdiction for an accused person to be released on the ground that the basis of the charge or charges against him is not substantiated. The court simply strikes out the case and declare the accused discharged. In carrying out your analysis, you have to recognize the following. The meaning of acquitted. In parentheses, it means that the accused had been fully tried by a competent court of jurisdiction and was not found guilty of the criminal charges against him. To this extent, the person can no longer be arrested and tried in the same substance of that case, having the same element. Always make your references within the concept of the law of that land. For instance, in Nigeria, this is a fundamental right recognized by the 1999 Constitution of Federal Republic of Nigeria in each section 36(9) or section 9. The section reads to the effect that no person who has been tried of a criminal offense by a court of competent jurisdiction shall be tried again in respect of that same offense having the same element, unquote. This is found in Nigerian Constitution of Federal Republic of Nigeria, section 36(9). That is what is telling you. When you are carrying out your work, you must always ensure that you make a reference where your point is coming from and where you are basing your argument. Now we have to look at court orders and the reluctancy of governments to accept court orders. You have to realize that in some cases it is a universal issue. In some countries, government obey court orders, especially in the developed countries. But in third world countries, some government officials refuse to adhere to constituted orders of the court. In this very discussion, we will look at various countries, various orders, and what experiences each country has had on this very issue of obeying court orders and disregarding court orders. In your studies, you have to also look at various constitutions, especially the constitution of the country where you are basing your argument. Does that country has a written order or in their constitution where they stated government should disobey court orders? It is very, very important to note that. Where there is none, then you try to locate reasons why such government at a particular point in time is disobeying the orders of the court. According to U.S. Justice of the Supreme Court, Justice Louis Brandeis, stated, in a government of laws, the existence of government will be imperiled if it fails to observe the law scrupulously, unquote. He continued, government is the potent and omnipotent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man or woman to become a law unto himself or herself. It invites anarchy, unquote. Justice Louis Brandeis of the U.S. Supreme Court. Indeed, court orders have the impelling force of rule of law and fundamental constitutional values that the government must respect in order to preserve the ever-fragile fabric of constitutional democracy. It is observed that there is an increasing hostility to court orders by government officials. But there is a question: how does courts deal with these situations within the framework that the law affords them? This is a question that needs answer. In this research to find out what the answer should be, then the Supreme Court judge gives a little open eyes to what the answer should be. First, he suggested that the court must realize that so long as they look at the government as an amorphous body of unspecified and unspecifiable individuals, we are never ever going to find a solution to this problem. Any redemption from the current situation is possible only, I quote, if personal responsibility for disobedience or obedience of court orders is fixed on specified officers or individuals in government, political or bureaucratic, unquote. This brings us back to the attributions on individuals in government taking responsibility of their actions, and also the government taking responsibility of the actions of those it employs or deployed and trusted their services. This brings us back to the reference point of the case between the federal government, of which the government of Nigeria charged Nnamdi Kanu of some criminal offenses. The matter became a court issue of which the court has to determine the outcome of the charges against the accused. This was supported by the President of Nigeria himself, who stated that, I quote, Buhari says only the courts will determine IPOB leader Nnamdi Kanu's fate. This was on May 6, 2022, reported by G.K. Olisa of Nairametrics newspapers. This was stated according to the reporter. He stated, Buhari said, I quote, I have listened carefully to the various appeals from the elders to the traditional leaders regarding a wide range of options. I have said previously, this matter remains in the full purview of the courts, where it will be properly adjudicated, unquote. Please, I have to repeat, when you are carrying out your research work, as long as the human rights issues are concerned, ensure that you make references to those officers, to those who, or newspapers, or news media, where your reference points are coming from. Well, one will say, on the 13th of October 2022, the court adjudicated and made its rulings and orders. This, according to what has come to public, that the court stated that the accused has been acquitted. In reaction, the Justice Minister and the Attorney General of the Federation, Mr. Abubakar Malami, reacted to the judgment of the appeal court in Abuja on Thursday, quashing the charges against the leader of indigenous people of Biafra, Nnamdi Kanu, saying that Nnamdi was only discharged by the court and not acquitted. In reaction to the appeal court rulings, the Métis Allah Cattle Rearers Association was not happy either. They stated, Nnamdi must not be released. Métis Allah wants. According to Pan Fulani Group, Métis Allah or Makban, that expressed dissatisfaction with the appeal court's verdict. The question still remains, should the government of Nigeria dishonor the court orders? According to Justice Louis Brandeis of the U.S. Supreme Court, the United States of America was involved in this very dishonor of the court orders until the judges themselves organized themselves, then came out with the solution of apportioning individuals in the government to take responsibility of dishonoring the order of courts, and of which they were persecuted according to their decisions. Should Nigeria go to this type of decision by persecuting individuals that disobey court orders while they are in government? Should President Buhari be persecuted after his tenure of office for disobeying all court orders while he was in power? Will also the Justice Minister, Abubakar Malami, be persecuted and sentenced to imprisonment for disobeying competent court orders during his tenure as Justice Minister and the Attorney General? Historically, these are how Western world stopped governments from disobeying court orders. In a system where the third world countries, especially in West Africa, and more particularly in Nigeria, where court orders are being flawed, are being disobeyed by those in government, and this makes it possible for other subsequent government officials to behave in similar manner and make references of the past regime that never obeyed court orders. But when it is attributed to individuals that made it possible for the court orders to be disobeyed and be punished, it will subsequently stop such menace in government circle, whereby individuals will disobey court orders if it did not favor them. Again, we will also discuss on the issue relating to the abuse of office of the present president, beginning when he was a military head of state. He does not believe in justice system. He believed in military tribunals and the secret trials. But however, it should be stated that resorting to military tribunals and the secret trials, which the President Buhari used during his military era, violated the human rights of Nigeria. The practice is considered a major setback in the human rights violations. Nigeria is known for its human rights violations, and the leaders also committing crimes against humanity in its process to carry out what is called extrajudicial killings and the trials. This does not go in line with the process of fair trials. The president in the current dispensation, with the Justice Minister and the Makban Mehti Allah Cattle Rearers Association, they are not happy because the procedure of the court discharged Nnamdi Kanu. Unlike the military tribunal system they wanted to adopt for the criminal trials, which ensures undue process. The military tribunal is an orthodox method of dispensation of justice. It does not pass the test of rule of law and due process. The military tribunal is illegitimate, purely made for the persecution of their perceived opponents and critics. Buhari, in his heydays as the military head of state, disregarded the rule of law and the fundamental rights of Nigerian citizens. In his days as military head of state, he believes in the arbitrary arrest and detention of persons, including extrajudicial killings by the secret services. The right to life is a fundamental right and the basis of enjoyment of human rights, but these are ignored by the dictators who want to use unlawful means of justice to execute their opponents. The president and the allies, the Makbans and the justice minister are not happy because the normal due process of court took place. But we will make reference to 1985 issue, whereby the president constituted a military tribunal to try those who contravened Decree number 20. The tribunal was headed by Justice Adhired Desami. In this very tribunal, they sentenced some Nigerians, the youth, to death for allegations of drug trafficking, of which the world, the human rights organization, led with the military head of state then, who is also General Buhari, but he refused. Making reference to this, the tribunal on April 10th, 1985, on a Wednesday, executed publicly the following on order of General Buhari by firing squad: Bartholomew Owu, 26, Lawal Akini Odelabe, 30, and Bernard Ogedembe, 29 years, including a young lady, Caroline Iyama, who was also found guilty by the same military tribunal headed by Justice Adhired Desami. Then referring the case of Nnamdi Kanu and the federal government of Nigeria, whereby the same General Buhari is the current president. Like those days, he swore in Justice Adhired Desami to handle the tribunal he set up, the military tribunal he set up, that sentenced the 3 aforementioned youths for drug peddling. He also, on the 12th October 2022, as reported by Punch newspapers, Buhari sworn in Areola as substantive Chief Justice of Nigeria. Like Justice Adebayo, Desami was compelled to handle the case of the tribunal of those who contravened, according to government of Buhari then, Decree 20. Buhari and Malami had the aim that the current inaugurated new Justice of the Federation, Justice Olukayode Areola, would also take the same step Justice Adebayo Desami took in 1985. There is a system that, through the research available to Massive Human Rights and Freedom Initiative, that the government of Buhari applied the principle of tribalism in carrying out some of its injustices in Nigeria. One, it was a Yoruba man to say that was the justice that sentenced Mr. O. Batlomi, Mr. Akeni Alawope, then Mr. Bernard Ogedembe to death. Now he has inaugurated another Yoruba man to handle the case of Nnamdi, of which they felt that the court will abandon the principle of justice and fair play to find Nnamdi Kanu guilty of the government alleged offenses. In another incident you have to note is that Nigeria has always been accused of corruption, and in the recent time the Justice Ministry, especially the judges, have been accused or alleged to have been taking bribes, and the judges themselves can be able to testify who compels them, if at all they do so, to take the bribe. But to forestall and sanitize their system, before the new Chief Justice of the Federation, in the name of Justice Olukayode Areola, was sworn in, the Supreme Court of Nigeria made a pronouncement. They said, according to the report of the Guardian newspaper of 5th August 2022, I quote, "Stop night visits to judges' residences. Supreme Court Justice tells government officials," unquote. The judge frowns on flagrant disobedience of court orders. Supreme Court Justice Inyang Okoro, I quote, has said the judiciary will only function effectively when it is devoid of state interference, including nocturnal visits to judges' residence to curry favor, unquote. He further warned that the trend, if unchecked, could push the country into anarchy. He said an allegation that a judge is incompetent on account of conflict of interest, bribery, or lack of technical skills capacity will erode the confidence of the citizenry in the judiciary as bastion of democracy and the rule of law, unquote. This is a warning to the government officials from the judiciary, from the Supreme Court judge or judges, or from the upper chamber, warning the government officials who corrupt them or who tend to abuse the process of law by giving bribes only to come out to abuse the judges that they collect bribe. In stating this, he further stated that to ensure that the judiciary discharge its responsibility without fear or favor and maintain its independence, the government arms, that is the executive arms and the legislative arms, should stay clear of the Justice Department to enable them to discharge their responsibilities without fear or favor. And this is where Mr. Malami and the President Buhari is hanging, because the judges have decided not to accept bribe, accept anything, gratification, to enable them influence the justice against whosoever the government want to imprison. This was disclosed during the Nigerian Bar Association section on public interest and the development law, a lecture they termed Undermining Judicial Authority in a Democracy, Cause, Consequences, and Solutions, unquote. On final analysis, the judge scolded lawyers and the parties involved and warned that disobedience to court erodes confidence in the judicial system, unquote. The aim of apex court judges, that is the Supreme Court, is to ensure that what happened in 1985, April 10th, never repeated itself in the present democratic dispensation, of which President Buhari is the president of Nigeria. They do not want what happened before to repeat itself, as they realize that Buhari and the Malami started taking the same process Buhari took in 1985. So this can be seen as blocking the targeted personality they want to imprison without due process of law, with abuse of human rights, disregard the judicial process of Nigerian Federation, without standard proof of evidence to convict a person based on flimsy evidence, blocking the power to impose severe punishment where there is no proper proof of guilt. Like Buhari's tribunal in 1985, they did not follow the regular procedure of criminal trials and they failed to establish the due process. This is what Malami and the Buhari want to repeat. But in this case, you have to realize that the present day judiciary, especially those handling the case of Nnamdi Kanu, knew that the international community is on the watch to prove how the judicial system can work under normal circumstances where there is no influence. They have realized now that they, given the opportunity to proceed their judicial system without interference, without bribery, influenced by the government officials, Nigerian judges can prove also that they have the same capacity to dispense justice just like those of the Western world. So that is how the judiciary proved the politically motivated cases against Nnamdi Kanu was proved abortive by the government of Buhari and the Justice Minister Malami Abubakar as Nigerian Minister of Justice. Therefore, we have reviewed this, and I encourage you in your approach, in any publication, in any letter you are going to draft. I want you to indeed make proper review, proper research, and the references before you publish, before you make a report about the human rights and the operational systems that you found not worthy of emulation within the community. With this, we come to the end of this very review. For our viewers and friends who watch on the YouTube, we ask you to subscribe, share this video globally, give us your thumbnail, press the notification bell, and leave your comment. You give us the best suggestions, best comments, and your opinion freely. We will come back to you, or we will use them for further research. With this, we say peace to you all, and God bless you. Bye.